Yes, Mr.
My lord, my ladies, good morning to you. I appear on behalf of the appellants together with my learned friend Mr Beasley, and my learned friends Peter Knox, KC, and Catherine Bailey, therefore the respondent. My lord and ladies know that this is an appeal against two orders of Mr Justice Freedman that were made back in 2022. The decisions were made, the orders were delivered and sealed on the 17th of December 21 and the 18th of March 22. The appellant's notices were issued on the 7th of March and the 17th of May 2022. There are two appellants, AAM UK, or Astra Asset Management UK, and Astra Asset Management LLP, which I'll just refer to as Astra UK and Astra LLP, if I'm allowed to. And there is simply one respondent that was the claimant in the action that I'll refer to as Musst.
Yes.
The two orders against which there are appeals. The first order is the order whereby the judge ordered ordered Astra UK to produce statements of the commissions that it said were due under a contract, which I'll refer to as the Octave contract, made with two other parties. The first party called Octave LLP, and the other party called Octave Limited. And that was an agreement dated the 18th of April 2013. In the second order, the judge ordered Astra UK to pay the sum of $3.8 million into court on account of the sums which it might find due owing under the terms of that contract as novated to Astra UK. There are three grounds of appeal in the two appeals. The first ground of appeal is that the judge was wrong to hold that the obligations of Octave LLP and Octave Limited, both of those obligations under the Octave contract, were novated firstly to Astra LLP and then secondly to Astra UK. That's what I'll call the novation issue. The second ground of appeal is that the judge was wrong to hold that Must's entitlement under the Octave contract continued indefinitely, irrespective of whether or not the investments continue to be eligible investments as defined by the Octave contract, and that's the eligible investments issue. And then the third ground of appeal is that the judge was wrong to hold that Must's entitlement continued beyond the date when a particular fund called the Astra Special Situations Credit Fund, which I refer to as ASSCF, after the date of that fund's restructuring, when it and the managed accounts that up until that time had been following it ceased to be funds as defined by the Octave contract. And that's what I refer to as the funds issue. If ground one is correct, my lord and ladies, then both of the orders, we say, should be set aside, and the matter should be remitted to the judge for determination of the alternative claim that the judge didn't make a decision on, namely the claim in unjust enrichment as opposed to contract. If grounds 2 or 3 are correct, then only the second order, we say, should be set aside, and then the matter should be remitted to the judge for determination of the correct amount of quantum. My lord and ladies may have seen that on our calculations the difference is about 1.2 or 3 million pounds, something like that. There is a respondent's notice, as my lord and ladies may know, which raises an additional ground of objection to the second appellant's notice, which is ground 3. But it only arises if the court is willing to allow the appeal on that ground, and I'm going to let my learned friend advance that in his submissions as an if necessary. The court has been provided with an agreed reading list, which I hope my lord and ladies have had an opportunity to consider, a bundle of authorities, and an agreed chronology. I actually have 3 bundles, but I can see this morning that there are 5 bundles that everyone else has. I am told that there is a split in the core bundle and a split in the supplemental bundle at pages 363 and 491 of those bundles.
All right, shall we? We'll approach this empirically and see what happens when you start
exactly
calling the numbers.
I just flagged that. Yeah, exactly.
Yes.
Thank you very much.
All right. Well, while I've interrupted, can I just see what you've told us so far? What's the total amount that's in issue in these proceedings, then the must claim at its highest amounts to
3.8. We say $3.8 million. There are
dollars.
Dollars.
So in pounds,
Say around about 3.5 million.
right? So the whole thing's about. All of this is about £3.5 million.
On our case, my lord, yes. And
Well,
the reason I say that is because there are still unresolved issues in the proceedings. In particular, there is a claim that's advanced to what is described as Crown 2 and Crown 3, which are other managed accounts, which is still unresolved.
Right, 3.5 million and some on his case.
Yes.
And the costs that have so far been incurred on both sides?
I don't know, my lord. I think our costs. I'm told 2.5 million.
2.5 million for Astra and for Musst?
My lord, I don't know off the top of my head. Can I just take instructions, either now or over lunch? I need to ask those behind me.
Right, but
It's not likely to be all that much less. I mean, it's going to be, I imagine, over a million.
so we're in territory where even before an appeal, the costs exceeded the sort of amounts that we're talking about.
If you top them up, I couldn't say yes, but I
Yes.
couldn't say no.
All right. Well, it's just a feel for it.
My lord, that's right. My lord may know that there's another claim as well that was issued around about the time when this matter came for trial, a separate claim, which is also a claim to Crown, what's described as Crown 2 and Crown 3.
Yes.
And that there's been an application to strike out that claim, and I think that the indication that I've been given would include all the costs of everything, all of those claims.
Understood.
There's-
Now, how have you divided up the time between you before you get into your submission?
Yes. So my learned friend and I had a discussion yesterday about this, and we agreed that I would take the most part of today,
Yes.
making my submissions in support of my appeals, and then my learned friend would have about the same amount of time to answer that and move his respondent's notice if he wants to, and then that would leave some time for replies.
Good. All right. Well, unless my ladies have anything else by way of throat clearing, let's start.
Thank you very much. So I'll take my submissions in the order of the grounds as I've indicated them. First of all, ground 1, the novation issue. And my lord and ladies may realise that the essence of this ground is that the judge failed to apply the admittedly correct analysis that he had set out in his judgment, the legal principles on novation, to the facts as the primary facts as he found them to be. And in order to explain the judge's error, I propose to first of all examine some of the underlying documents, which is the basis on which he reached the conclusion that there had been a novation. This is a case where the question of novation really depended largely on undisputed facts, based largely on the documents that I'll be showing to my lord and ladies, as pleaded in the re-amended particulars of claim. Secondly, I'll then just very briefly record the legal principles with which there was no dispute below, and I don't think there's any dispute here. Thirdly, I'll examine the claimant's pleaded case on the novation, and then fourthly, look at the judge's reasons and submit why the judge fell into error. What I'd like to do, if I may, is invite my lord and ladies to pick up the agreed chronology, where I think is a useful starting point to look at the facts. I've got it at tab 5, page 69. My lord and ladies will have seen that the background starts back at the beginning of 2011, when Mr. Mather formed the idea of setting up this fund that then became the ASFCF fund. And that was to invest in synthetic asset-backed securities from which fees could then be earned. He then was introduced to Mr. Siddiqui, and the claimant was then formed. over the page, in March of 2012, the strategy began to be marketed to potential investors, and then there was the introduction to the two clients, LGT and the observatory. So that's Crown and 2B, as I refer to them. We then have the launch of the fund, which is important, on the 30th of November 2012. And what's important about that, my lord and ladies, is that it was launched with Octave Investment Management Limited, so that's Octave Limited as the manager of the fund, with Octave Investment Management LLP, so that's Octave LLP as the investment manager of the fund, and indeed it had Astra LLP as the investment advisor. It may assist, if I could just invite my lord and ladies to pick up the supplementary bundle and turn to page 108. My lord and lady should have the prospectus, or an extract from the prospectus, dated the 30th, at the bottom of the page, 30th of November 2012. So this is what the fund looked like when it was launched, my lord and ladies. At the top of the page, after the heading Astra Special Situations Credit Fund, you can see that Octave Investment Management LLP is the investment manager, Asset Management LLP is the investment advisor. Sorry, Astra is the investment advisor. And then over the page, 109, you see the three different parties there: manager, investment manager, and investment advisor. So there were three separate roles that were being performed in relation to this fund, according to the prospectus. And we don't have within these bundles, but there was no issue that there was agreements with all of them between all the different parties for the different roles that they fulfilled in relation to the fund. So that's the prospectus of the fund. That's the fund itself. If we then look from there, go back to the chronology, ladies, to the 11th of February 2013, we have the investment management agreement between Octave LLP as the investment manager and 2B. So that's what we call the 2B contract, as defined within the pleadings in this case. And we can look at that very briefly. We can see that it's in the supplemental bundle at page 110. And if I could ask you to look at page 113, and all ladies can see that it's an agreement between 2B, that's the client, and Octave LLP. So it's an agreement that it's not made with the investment advisor to the fund, it's not made with the manager to the fund, it's made with the investment manager of the fund, Octave LLP. And essentially, my lord and ladies, what it shows, and if I just ask you to look at paragraph 4.1 on page 115, that the investment manager is going to manage the portfolio, which is basically consists of the assets, on a discretionary basis. And then a wide description is given as to the investment manager's powers. And the other thing I just draw to your attention at 4.7 is that the parties agree that in managing the portfolio, the investment manager should not be under a duty to any way to replicate any other fund. The point I wish to emphasize is this, that under the terms of the 2B contract, the investment manager, Octave LLP, was given a wide discretion to achieve a profit, if you like, on the investment. And the powers it was given under the terms of the agreement were not tied to what then became known as current strategy. They could follow any strategy under the terms of this agreement.
Can I just pause there and make sure I've understood? You've taken us to the prospectus for the fund.
Yeah.
You've taken us to this contract. My understanding is that this contract gave rise to something that both parties accept, or all parties accept, as a so-called managed account.
Yes.
As opposed to the fund. In other words, if I've understood it correctly, the investments that were made under this account were made, this is the 2B contract, I think, isn't it?
Yes.
Made and held by 2B, but managed by Octave LLP at this stage, as opposed to the fund that you took us to earlier, which is a separate entity
Yes.
through which other investors invested. Have I understood
That's
correctly?
absolutely right, my lady. That's absolutely
Thank
right.
you.
And as I'll show you in a few minutes' time, that the Octave contract engaged not only the fund, the ASSCF, but other funds and managed accounts
Yes,
that
indeed,
replicated it.
indeed.
So the point
was
is,
part
here
of my
we have
question.
an investor, in this case 2B, might be very happy to just join with everyone else in the fund, in the ASCF. Or alternatively, for their own commercial reasons, they might like not to do that, but to have their own fund or managed account.
Yes.
And that's what happened here. They didn't join with every other investor. They had their own specific account. But the key point when it comes to the Octave contract and the right to fee sharing is the replication of what the fund ASFCF was doing.
Yes, although you've just taken us to provisions of the contract which say effectively we don't need to.
That's right, and
follow
that's the point I'm making, is that
strategy.
under the terms of the managed account, the 2B contract, it wasn't necessarily the case that this portfolio would be managed by replicating the fund. It's a possibility, but it wasn't an obligation. And that's the point. It allowed a change of strategy within this managed account, so that the manager could either follow current strategy or not, as he saw fit. So that's the 2B contract. The only other thing I'd like to show my Lord and Lady about that is the fees and expenses section on page 120. And paragraph 13.1, the manager, the investment manager, Octave LLP, would receive two things. First of all, a 2% per month management fee, and that would be based on the net asset value of the fund or the initial capital contribution, that's subparagraphs A and B. And then that monthly fee, paragraph 13.2, would be payable monthly in arrears. And then secondly, it would receive a performance fee, which is calculated in accordance with Schedule 4. That's paragraph clause 13.3. And if one just turns to Schedule 4, page 135, one can see at paragraph 2 that the performance fee was 20% of the net return as defined in respect of the portfolio. And the net return, then, as a definition immediately below, is the net asset value of the cash or other assets withdrawn by the customer in excess, ... in excess of the aggregate contribution. And that would either be payable at paragraph 3 on a return being made, or under paragraph 4 on termination. And the point is that we have fees that are being paid according to the net asset value of the portfolio at different times. So obviously that would involve a calculation as to the value of the assets held by the portfolio at that particular time. And indeed, there were net asset value statements being produced on a regular basis to enable the parties to make sure that the fees were paid. So that's the 2B contract.
Sorry, just
Yes.
to clarify as well, it didn't jump out at me from the judgment as to whether both parties to the contract, all the parties to the contract were considering, would have been familiar with the terms of these contracts. Is that relevant? Is it common ground?
Well, I think it would be common ground that the parties all knew the terms of these contracts. These contracts were provided to the claimant, Musst, at the time that they were made. Right. So everyone knew what those terms were. That's
what I was wanting
yes.
to check.
So then the 2 points are, one, that the we'll get on to the octave contract in a moment, but one, the 2B contract allowed a wide discretion, as it were, in terms of what strategy would be followed, and secondly, it provided for fees payable on net asset values from time to time throughout the course of the contract. And we can then move, in terms of the chronology, to the octave contract itself, my lord and ladies, which we have in the core bundle behind the particulars of claim, and it begins at page 342.
Say that again.
342.
340.
My lord and lady will see that it's an agreement between three parties, and it does not include Astra LLP, the investment advisor to the fund. It's made with Octave Limited and Octave LLP. And it's made, as my lord and ladies can see on page 344, under the heading Parties, in the same capacities as they had in relation to the fund. So that is to say, it's made with Octave Limited as manager of the fund and Octave LLP as investment manager of the fund. And Musst is referred to as the introducer. And as appears from the recitals, what is intended is that the introducer, this is at C, will introduce investors in the funds. And that's got a plural. So it's not just ASFCF, as we'll see in a moment, but in the funds. And we have a definition of funds on the next page, 345. That is the ASFCF fund and other funds and managed accounts designed to substantially replicate the investment securities and risk profile of ASFCF and substantially the same strategy as set out in current strategy. So that's two conditions. If it matches, if it replicates the securities and risk profile and it follows the same strategy as current strategy, then it could be included within the definition of fund. And so that, my Lady Justice Falk, that shows that the correlation that I was discussing with you earlier. It shows that it's it's not just the ASFCF, it can include other things. It could include, and did include here, the 2B contract, that was always accepted.
Yes.
But provided, this is the condition, provided you've got the replication and you're following current strategy. So we can move from there, and I'm sorry, whilst we're at this definition, I'll just highlight, I will deal with this in more detail under the grounds 2 and 3 of the appeal, the last sentence of that definition, that it's understood for the purposes of interpretation of the definition of a fund that the strategy remains substantially similar to current strategy. Mm-hmm. Important words that I highlight: a fund and remains. So I would submit, and submitted below, that the reference to a fund is any fund, and the word remains indicates that you don't just consider the question at any particular fixed point in time, but over a period of time. In other words, this is a continuing requirement. Now, we go from there to the definition of current strategy, which is, current strategy is not on the left-hand side of the page, it's at the bottom of 344, the definition on the right-hand side of the page. That's a multifaceted definition, and what it does is it ties what Musst was doing and the right to fee sharing to a very specific strategy that fulfills this criteria. I think there are 6 parts of it. So it's investing primarily in synthetic asset-backed securities on a buy and hold basis with limited or direct leverage, such that the investments will operate as closed-end investment pools with capital committed on a locked-up basis for several years to be returned to the investors in such funds following realisation. So that's the strategy. I don't think anything turns specifically on that being fulfilled, but the point I want to make is that that is a very detailed definition. And the reason for that was that the right to fee sharing was to be delineated by things that were following this particular strategy, as we'll see just in a moment. And when we look at the entitlement to revenue share, which begins at paragraph 3, page 347. So the introducer, sorry, just show my lord and ladies at paragraph 2.1, is appointed by the manager of the fund from the effective date, subject to the terms of this agreement, to introduce prospective investors under the terms of this agreement. And then at 3.1, the introducer is entitled to share in all management and performance fees earned and received by Octave or any of its affiliates, over the page, in respect of each prospective investor who makes, indirectly or directly, an investment in a fund. There's the connection with the term fund. Managed or advised by Octave, the second part. So first of all, fund. Secondly, managed or advised by Octave for the current strategy. That's the third part. Those are the three important parts so far as this appeal is concerned. And then on or before the cut-off date. So that is the, and then each...
What's the cut-off date?
The cut-off date is a period of time, we have it in the definition, it's 9 months after the termination date. The termination, and the termination date is dealt with within the termination provisions.
So what's the termination date?
So it goes on essentially indefinitely until notice is given.
So those are the provisions that
Yes.
that specifically cover longevity.
Yes. Sorry. Yes, that's right. The 12.1, the agreement continues in force for a period of 6 months, the initial period, after which it will continue until terminated by a party on not less than 30 days' notice.
Right, and it's not said in this case that that process was followed.
No, it's not said that.
Those are the, and just so I'm clear, those are the only provisions that, as it were, by which the parties explicitly set a, as it were, sunset moment for this agreement.
For the agreement itself, yes. Yes. There are other termination provisions.
But I appreciate one could,
Either way, but
the agreement could cease to be effective for other reasons, which is why we're here.
yeah, indeed.
But we're not concerned here with the provisions which, in fact, explicitly brought it to an end.
Yes, that's correct.
Thank you.
Correct. And so that would give a quite potentially long period of time over which this agreement would operate, and so that might mean that there could be investors introduced either over a long period of time. It could mean a right to fee sharing over a long period of time, depending on whether or not these conditions were satisfied. Absolutely. And that's why in the second round of appeal, it's described in the way that it is, my lord, namely that this is an unlimited, the construction that the judge has found is unlimited in time, and it's not limited to whether or not these funds were still following any of the requirements within the definition of funds and current strategy. That's a particularly important part of the background to the construction that we say is the correct one of this agreement. So, my lord and ladies, we see there that within clause 3.1 we have the definition of what is an eligible investment. But that provision does not say, we submit, how long that entitlement is to last for. It simply identifies what is an eligible investment. In order to see that, we have to look at the other terms of the agreement. Clause 3.2, clause 3.1 does not either identify what the right to fee sharing is, what its scope is. 3.2 does that. It says, unless otherwise agreed between the parties, the revenue share shall be 20% of all fees earned by Octave or its affiliates in respect of any eligible investment. So it's 20% of fees earned, and it's tied to eligible investments in this way. We then go from there and ordinates to paragraph 3.6, which is something that we say is important, particularly important in the context of the novation argument, namely that the sole obligor for payment of any of the costs and liabilities shall be the manager, who, as we've seen, is the appointor in this case. And the investment manager's functions are limited to A, the performance of such actions as may be required by the manager to be undertaken to facilitate the operation or administration of the agreement, and B, the performance of such other activities or functions may be delegated under the terms of an investment management agreement in relation to the fund. We can ignore the second part of that for the purpose of this agreement. It's really limited to the operation and administration of the agreement. We say that's important in understanding how the parties conducted themselves. One has to frame how they conducted themselves within the terms of this agreement.
Can I make sure I've understood the point you've just made? If you go back to 3.1, the fees courts pick up fees either earned by Octave, which is defined to actually cover both of them, or any of its affiliates. So it's not a question of saying, well, fees earned by Octave LLP are not within the remit of the agreement. As I understand it, they
That is correct. That is correct.
and also, when you took us to the Crown, the Crown or 2B, you took us to the managed
The 2B contract, yes.
Contract, as you also pointed out, that is with the LLP.
Absolutely.
And therefore, any fees earned under that contract would have been earned by the LLP.
Absolutely. That's absolutely correct.
So, although I see what you say in 3.6,
Yes.
it's not quite the whole story.
Well, the key point I would submit is this, that the obligation to make payment rested only with Octave Limited. It did not matter for the purposes of the agreement, that's the point I'm accepting, whether the money was earned by Octave Limited or Octave LLP, or indeed an affiliate. That was not the relevant factor. The important factor is that only Limited is liable to pay the revenue share. And the reason that is so significant is that the entire case of the claimant here is that because Octave made the payment, therefore it should be regarded as having had novated to it all of the rights and obligations under the agreement. And I hope to
Astra, you mean?
Yeah, that's correct. Sorry, Astra, yes. Because Astra LLP made payments, therefore it should be treated as having had novated to it all of the rights and obligations under the agreement. And that's the point at which I say that's a step too far. It's just a non sequitur, that argument, as I hope to show you in a few moments. But so the key point of 3.6 is there are these two different functions under the terms of the agreement. It doesn't matter who earns the money, but only Limited is liable to pay. And LLP's obligation and role is really administrative and operational under the terms of this agreement. We then have clause 3.7. This is a clause which is more important in relation to grounds 2 and 3 than the novation ground, but I highlight it now. I'll come back to that in a few moments. It's essentially saying that where an investment is made by an investor in what's described as a new fund, which would include here a situation where the ASFCF has been restructured, then the entitlement to fee sharing ends, and but this does not affect the claimant's right to fee sharing for the period when the fund was following current strategy. So there is a division, if you like, of the period of entitlement. It doesn't affect the entitlement, but entitlement is only the period when it's following current strategy. That's 3.7. And then 9.4, this is the point that was relied on by the claimant in support of the claim, namely that there's an obligation on Octave to do such things within its power to ensure that responsibility for management remains with Octave. And then the next the sentence in the middle of the paragraph is the critical one. Octave shall do all such things and exercise all such rights as may be reasonably within its power, so as to ensure that responsibility for the management of any fund or managed account is not transferred to another party without the consent of the introducer, unless such party offers to enter into effectively an equivalent agreement. So the way it was presented was as a sort of absolute obligation. The way the judge interpreted that was as a sort of absolute obligation. And the point I just want to make at the moment is that it was never an absolute obligation. Plus, it was only a best endeavours, if you like, obligation. And secondly, it was qualified by the two ways that I've just shown the ladies, namely that as a consent and also an offer from a third party. So that's
what on your case is that paragraph, that clause there for?
well, it's to it imposes an obligation on Octave to essentially use its endeavours to keep hold of management of the fund. That's it. In other words, it anticipates that there's a possibility that
not just to
will move elsewhere.
as it states. I'm sorry to speak over you, but not just to keep hold of the management of the fund, but if it lets it go, to let it go on terms that are no less advantageous to Must.
If it has the power to, as it were, retain it, if it's going to let it go, either with consent or on terms that are advantageous to Must, I accept that, yes. The key point being that that's an obligation that Octave will come under in certain situations. Whether it came under it in this situation is another matter. We submit that it never came under the obligation here because what happened was Astra split from Octave. It was no longer, and this is common ground, it was no longer the investment advisor to the fund. With that, it was no longer able to keep hold of the management of these funds, and therefore, and that's why Astra LLP entered into what we've described as the second 2B and the second.
But this is Astra and Octave that have the same address.
They did for a while, my lord, that's right.
And there was also an actual agreement between Astra and Octave, wasn't there?
There was an agreement between Astra and
Are you
Octave.
saying that's not relevant to...
Well, under the terms of that agreement, call it an agreement, it was a letter, I think, properly speaking, Astra acknowledged that it was not going to be in a position to keep hold of the management of these funds.
You mean Octave?
Sorry, yes, that's right, Octave. Yes, that's right. So I wouldn't put it as high as an agreement, but yes, certainly.
Okay, so you're...
I don't shy away from the reality that what happened here was that the management of the funds moved from Octave LLP to Astra LLP under the terms of the two different agreements that were entered into.
But that was because Astra became competent to manage it.
Yes, in part, that's right.
It was a purely internal sequence. That had been, I think the judge found, had been contemplated all along.
Well, it was a possibility, certainly. That was always...
A possibility that had been contemplated all along.
It's a possibility that management would not remain with Octave.
Right. So we crystallise understanding of your point about this. So why does 9.4 not bear on this?
9.4 imposes an obligation on Octave to do certain things in certain situations. It doesn't follow that 9.4 has crystallised or that anyone is in breach of the terms of 9.4. That requires a consideration as to whether or not Octave was in a position to do something, and it requires a consideration as to whether or not Must was content with the transfer of the management, and it also requires a consideration as to whether or not there was an offer from a third party.
One assumes that Must would be content with the transfer if there weren't extraneous factors, if it continued to get paid, but that it wouldn't if it didn't.
Well, but my lord, that, if I may say, I understand that commercial. Of course, I understand that, and I think that it's fair to say that that's to some extent what is anticipated in the last condition there, with the third party making an offer to enter into a contract. But what one has to do is to look at the exchanges between the parties to ascertain whether or not either this obligation was triggered, and that in turn depends on what was said between the parties, and in turn depends on whether or not there was an offer. And what we say is this was a situation where there was an offer from Astra Capital to enter into an agreement to take over the role of manager, and that was an offer also joined with by Astra LLP to enter into the same role that had been fulfilled before that of Octave LLP. So that condition or rider was satisfied. So there wasn't.
Well, hang on. We need to be potentially careful about timing here. That what you refer to as that offer was made some months afterwards.
I will show Lady and Lord the documents that make good that proposition.
Okay.
I do accept there wasn't exactly at the same time. The draft agreement wasn't sent at exactly the same time as the earlier email from Mr. Holden on which the whole case turns, and I say that's not surprising, because I mean the email was simply asking Musst to address invoices to a certain person. And I'll make my submissions on that.
So you're have I understood your case to be that there was no breach of clause 9.4?
Yes. There wasn't a breach of 9.4. I draw it to your attention. I accept it's potentially relevant, but certainly that's our case. The judge has sort of interpreted this clause as some sort of an absolute obligation not to transfer, and I'm drawing your attention to the fact that it's not actually expressed in that way. It's much more permissive than that, and it's an obligation that is one on Octave. It's not an obligation on Astra to do anything. The reality is that Astra was the party who, Mr. Martha was the party who invented this strategy that had the ability to pursue the strategy. And it was Astra that was in a position to take over the management of the role once Astra was ready or wanted to do that. And there was nothing that Octave could do about that. I mean, it would have presumably liked, for the same commercial reasons that Musst would presumably have liked to have ensured that it retained money. Octave would have liked to have continued to earn money.
Well, with respect, we do have to be careful about not giving evidence, because you say there's nothing Octave could do about it, but we've got to look at the evidence that was before the judge and what the judge found.
Yes.
And that included the exchange, I think it was a letter, you're right.
Yeah.
So between Octave and Astra. And that was followed, I think, by revised investment arrangements entered into in relation to these so-called managed accounts. So what came first was, if I've understood it correctly, the correspondence I've referred to between Octave and Astra saying we're essentially everything's going over to Astra.
I don't argue against that. I think that's right, Milady. That the letter that you're referring to, I think is the letter.
It's in August.
Is the 15th of August 2014,
Correct.
page 184 of the supplemental bundle. I think that's right. And what it said on the second page is that Octave LLP confirms to Astra LLP that the management services under the 2B and Crown contracts, I'm summarising, will transfer to Astra LLP, and secondly, that the fees payable to Limited will transfer to Astra Capital. So what it was doing was acknowledging the reality that there was now a new manager and a new investment manager within the fund.
You keep referring to the fund, but we are talking specifically about Crown and 2B, which is
We are.
not the fund itself.
No,
as we've
and that's
discussed
absolutely
earlier.
right. That's absolutely right. And the reason I mention that is because, yes, that is true. There were a number of agreements that the investment manager of the fund, Astra, of Octave LLP, had entered into, and they're listed at 1 to 5 in the letter. And the acknowledgement that's being given is that these services will transfer over to LLP. And the point I'm making is that reflects, this letter reflects the fact that Octave Limited and Octave LLP are no longer going to be the manager and the investment manager of the fund, and that instead Astra Capital and Astra LLP are going to replace them. And indeed, that's the very point that I wish to emphasise, and I'll do that by showing you the revised prospectus in a moment, that this was a case where it wasn't simply Astra LLP taking over the functions of Octave, both Octave companies. It was Astra LLP taking over the position of investment manager of the fund, and that included here entering into second agreements that had previously been with Octave LLP with the clients 2B and Crown, as well as other things, but those include. So I don't accept that there was any breach of clause 9.4, and I don't accept that this was the kind of absolute obligation that the judge sort of interpreted it as. And I do, however, accept that it was envisaged that there could be a transfer of management by this agreement. Not only in 9.4, my Lord and Ladies, but also in other terms of the agreement, including the terms of the agreement that I've shown you. So it's important, as I've emphasised already in clause 3.1, that the fees that are going to be subject to fee sharing were earned and received by Octave, not another party. That it was managing or advising the fund within 3.1, and that within the definition of funds that I've shown you, the last sentence in particular, that that fund remained substantially similar to current strategy, that there was this replication. Not only in those clauses, but also in the clause that I want to show you now, recognise that. The clause is 13.2. 13.2, I made the submission earlier. 3.1 essentially defines eligible investment. 3.2 essentially sets out the scope of fee sharing. 3.6 determines sets out who's got the obligation to fee share. 3.7 deals with a particular situation where there's an investment in a new fund. 13.2 deals with the question of how long the entitlement is going to last. Duration, rather than scope and the basic entitlement. And it makes clear, I submit, that the entitlement in respect of all eligible investments as defined in clause 3, so it links it to the definition in clause 3, continues for so long as such eligible investment in the current strategy are maintained by the investor. So the answer to the question how long is not found in 3.1, it's found in my submission in 13.2. That's an important point of construction.
Clause 13 is headed consequences of termination.
Yes.
Am I right in understanding that you're relying on 13.2 in not as limited to terminate a situation where the agreement has been terminated?
Yes.
Because one possible reading of it is to say, well, yes, okay, this clause is dealing with termination, but what it's saying is that despite termination, fees will carry on being payable. You're putting a broader
Absolutely, and I submit that's absolutely clear from the words that follow. That that clause can be split into the part that I've just read out, which then has a semicolon at the end of it. And then there is a rider, if you like, provided that, notwithstanding the foregoing, should this agreement be terminated following a repeated material breach of the introducer's obligations, including a sustained failure to comply with the obligation under 2.3, the right of the introducer to receive revenue will terminate as of the termination date. So in a certain circumstance that's then set out, then there is a termination of fee sharing. But unless that subset applies, then the entitlement just is continuing until the eligible investment is made, for so long as it's maintained in current strategy.
You're not reading the proviso as reinforcing an argument that the first part of that clause is dealing with termination, because you can say, well, one approach is to say, well, in normal situation of termination, fees go on, but if you've been particularly bad and had all these repeated breaches, then it doesn't go on. But you're reading the first part more widely than that.
I do, my lady, absolutely. I say it's not restricted to termination. And it doesn't say words to the effect that termination will not terminate the entitlement. It doesn't say that.
Right.
It makes the broad statement as to how long fee sharing is to continue for. And I say that is entirely understandable and links with the other clauses that I have shown you, which show that you have to look at the position, not just at the date, and this is, I think, a key point that we'll get on to with grounds 2 and 3. You don't just look at the date when the investment is made, which is what the judge found. You ignore everything that happens after that. In fact, you look at the position throughout, as all the clauses that I've just been drawing to your attention show, that what happens after the investment is relevant and can affect the fee sharing entitlement. So that's the contract. The only other things I want to show, my lord and ladies, are paragraph clauses 16 and 17, which I think I've drawn attention to in a skeleton argument, about no oral variation and no assignment without permission. And the assignment is wider defined. It would cover a novation. I submit that both of those clauses would cover a novation, simply because a novation involves, as we'll see shortly, involves an extinguishment of an existing contract, which is clearly a variation to that contract, and the entering into of a new contract with a new party, and therefore it's covered by the terms in clause 17, assign, transfer, mortgage charge, subcontract, or deal in any other manner with rights and obligations. I say that would definitely cover a novation. So that's the octave contract, and the octave contract, as you will have noted, was signed on behalf of the claimant Musst by its sole director, Mr Saxena. And the reason I mention that, when we get into the exchanges that relate to the draft contract, Musst made it very clear that it would be Mr Saxena who would be signing the agreement, that he would need to approve any change to the contract. Okay, so that's the contract. And can I just emphasize this point, that this contract, because it's with multiple parties, and the multiple parties, they have different functions, investment manager and manager, we have a situation which may or may not be usual. It doesn't really matter how usual it is, but it's specific to this contract, namely that there is a separation potentially between the person who received the fees and the person who's liable to pay. So it's not like a two-party contract where you've just got one person who's going to be invoiced and is going to pay. And that is why when one looks at the invoicing that took place, one has to put it into the context of this contract and the obligations that the parties had under the terms of this contract. So if I could ask you to look at the first invoice, which is in the supplemental bundle at page 339. It's the first document behind tab 16 in my bundle. One sees straight away that the parties never follow the practice of invoicing the party who was liable to fee share under the terms of the octave contract.
I'm sorry, I was just finding the page.
Yes.
Could you repeat it again so I make sure I'm in the
Yes,
right place?
yes. So we have
Page?
339.
Yes, I've got it, thank you.
This is the first invoice that Musst issued under the terms of the octave contract. And the invoice is issued to Octave LLP, the investment manager, not to Octave Limited, the manager, who was the party liable. And that is because of the context that I've shown, my lord and ladies, namely that LLP was to deal with the operational and administrative functions. It was the person, therefore, dealing with the invoicing, and must follow the practice of invoicing at Octave LLP from the very outset.
Are you saying that that wasn't in accordance with the contract, or could it be in accordance because of the delegation provision?
I say that it's not an issue of real relevance who was in office. That's my submission. But the parties never, often, or sometimes, it is relevant which party is invoiced, because it can show where the liability is. It depends on the evidence and the circumstances. What my submission to the court is that it is not relevant in this case, because we know that only Ella Limited had the obligation, and we know that Octave LLP's role was administrative and operational. And that is important, because when there was then a change of invoicing, it doesn't follow that just because a particular party was invoiced, that it accepted it was the party liable, or anyone thought that that was the party that was liable under the contract, because there'd always been a separation under the contract.
Who paid this invoice?
This invoice was paid by Astra UK.
Yes.
Not LLP and not
no.
Limited.
Exactly, so the whole point was that Astra were going to be paying. I mean, what the arrangements were for the payment to be made, but that was what was expected, that was what was done.
This particular invoice was paid by Astra UK.
Sorry, is that right? We're back in, this is the very first invoice,
yes.
Back in 2013.
Yes, yes.
I think you need to take us through that a little
Yes, let me do that by reference to the agreed chronology. Because although Astra UK paid this particular invoice, Octave LLP paid subsequent invoices.
Oh, I see. I see. At this stage, Astra is not authorised, and as I understand it, it's got some sort of investment advisor role.
That's
Suddenly
right.
has in relation to the main fund.
That's right, yes.
And it's got no named role on the managed account.
That's right. There was an agreement between Astra LLP and Octave. I forget now precisely who it was with, but I think it was probably with Octave LLP, whereby it would receive a proportion or some of the money that would be earned under the terms of the 2B and Crown contracts. And so Astra, in reality, Astra was always receiving some of the funds, if not the majority of the funds.
Yes,
that's the reality. But the reality isn't necessarily matched by the contractual obligations that the parties have agreed will govern their dealings. The parties were very specific in the Octave contract, but the person who would have liability would be Octave Limited, and only Octave Limited. But nonetheless, there would be obligations on Octave LLP to carry out certain functions. And so one of those functions was to deal with these arrangements of invoicing. And although I haven't shown you in the Octave contract because there was no provision for invoicing within the Octave contract. This was simply a mechanism that the parties found useful, as it were, to engage in, but it wasn't actually a contractual mechanism. So therefore, issuing an invoice doesn't represent any performance under the terms of the contract. It's simply the way the parties did it. And as you may have picked up, my lord and ladies, the way it worked was, on page 338, we have Octave LLP's first invoice to 2B. As a matter of practice, what happened was Mr. Holdem, who dealt with the administration side of things on behalf of Octave LLP, he sent a copy of that invoice to Musst, and then Musst prepared its own invoice to Octave LLP, which is the invoice at 339. That's the way it worked in practice. The point I'm making is that was not any part of the contractual conditions or clauses of the agreement. That's just the way they found it helpful to do things. And so I'm submitting to the court that the fact that the invoice...
Sorry, just a small point. A copy of the invoice was required to be provided under the agreement, I think. The invoice to the fund. Clause 4.1.
In clause
4.12. I don't think it's material.
Yes, they could. Hang on. Were they required to do that in every single case? I'm not quite sure. Certainly, they could. They would have to do it on request.
I think it does.
Let me just.
It's in 4.1.
My lady may be right. This is in.
So I'm looking at page 349.
Yes, and the paragraph
412.
412. Yes, I was just pointing out that at the beginning of that paragraph, lady, it says Octave shall, on request.
Oh, I see.
Yes.
Okay. Yes.
But perhaps Octave. Sorry, Musst could require Octave to provide certain particulars, including a copy of the invoice. The way the parties. So you're right in this sense. Musst could have required this invoice under the terms of the contract. What I'm pointing out is that just the way that the parties operated was just Mr. Holdem just gave them this invoice, and the reason why he did that was to show them the amounts, and it was transparent, if you like, and then Musst then produced their own invoice reflecting the amount in the Octave Limited invoice. 20%, and then it just copied it. But it addressed not the party who was liable, but Octave LLP. And what it's most of the time did, not always, but most of the time, it simply reflected the fact that that was the party invoicing. So in this case, Octave LLP is invoicing, and so the invoice goes to Octave LLP, but without really regard to the contractual obligation. That's why I say it's not significant in this case that the invoicing changed, or who the invoicing was to, because that did not follow the contract. So that's the invoicing. We then have I've shown you the 2B contract. We then have the Crown contract, which is in similar but not identical terms to the terms of the 2B contract. My lord and ladies have that in the supplemental bundle at page 136. And I'll take this very quickly because I've already shown you the 2B contract. This was called Trading Advisory Agreement as opposed to the Investment Management Contract. The 2B contract was called. Nothing else really on that. Again, it's made with the client by LLP, page 136. And again, at page 142, clause 5 of the agreement, there's a wide discretionary management power, not tied to current strategy. And then again, you can see that also, how wide it is from the terms of clause 5 of the agreement. And then again, under the clause 10, under the heading compensation, 2 fees are payable. First of all, an advisory fee, which is equivalent to the monthly fee that we saw before, and secondly, a performance fee, which is equivalent to the one that we saw before. But these fees are calculated on the basis of the trading level. That's something that wasn't in the 2B contract, it's something else. It's, in short, there's a definition. There's a definition on page 140, which provides that it's the latest amount in dollars which the trading advisor has been instructed by the client to manage. So it could be the case that the client puts in, say, $100, but only wants to trade with 50 of those dollars. It sets the trading level at 50, and that's the only money that can be invested. So it's based on the trading level. The fees are based on the trading level. And the advisory, as one sees at page 150, just after the bullets under A, the advisory fee, that's the equivalent to the monthly fee, is calculated and accrued in US dollars on each valuation day. So it's a very similar situation to the 2B contract. You have on a monthly basis an accrual, and that's based on the valuation of the assets within the portfolio and the trading level. And then the performance fee is again also triggered on an adjustment, in this case, of the trading level, but then there's a rider here for certain adjustments which are set out on page 151, not terribly significant, for what's called a hurdle. There was an additional hurdle that had to be met, and certain other things taken into account. And so there was a definition on page 151 of success fee amounting to 20% of the excess proceeds as defined. Again, so therefore there would be valuations on the reduction of a trading level that would then be based on the value of the portfolio at that time. And that's all really I really want to show you about this contract. And in a very similar way, once this contract had been entered into, we then had this sort of invoicing. Mr. Holden would provide Musst with a copy of the invoice that had been issued, in this case to Crown, and then Musst would then produce an invoice based on that, usually on the same day. And one can see the first invoice at page 341. 340 to 341. 340 is Octave's invoice, and 341 is Must's invoice. One further thing I'll just point out. These initial invoices were actually paid into Mr. Siddiqui's account. Although the invoices were rendered in the name of Musst Holdings Ltd, which you can see at the top of pages 339 and 341, the request, the bank account into which the payment was requested was Mr. Siddiqui's account, as you can see from the details at the bottom of page 339. And that then moved over eventually to an account in the name of Musst Holdings. But the reason I draw that to your attention, again, it shows that the parties are they're not acting with precision as to who is paying, who they're paying, who the invoice is made payable to, and whether that corresponds in any way to the obligations under the contract. I don't say there's anything wrong with it, but I say that one cannot place the sort of reliance that the claimant is placing on a change of invoicing against a background of this sort and against the obligations of the contract that I've shown you. So that is, if you like, the background to the novation as alleged. We then have, once we get into the actual novation itself, we have a change whereby, as I mentioned earlier, a revised prospectus is issued to investors because Octave Limited and Octave LLP are no longer the manager and investment manager of the fund. They are being replaced as such by Astra Capital and Astra LLP. The revised prospectus is at 227. It's dated the 12th of December 2014. and page 228, you've got the two, you've got the familiar now designations. There is no investment advisor to the fund anymore, for obvious reasons that Astra LLP has become an investment advisor, and there's no need for an agreement that it is the advisor to the fund. But other than that, there's simply a substitution of those two parties within the fund. And obviously, what I rely on very centrally here is the fact that it's Astra Capital that's the manager, not LLP.
Okay, but again, you've taken us to the fund, ASSCF,
Yes, I have.
which is not the mechanism for the Crown and 2B investments.
I entirely accept that.
Yeah.
I entirely accept that. But once it's not. It's important because my lady will recall the definition of fund under the Octave Agreement is ASSCF and any other replicating fund.
Right.
And that's the in short,
Okay.
in a shorthand. So this is relevant, very relevant, that there's been a change of manager and investment manager under the ASSCF. I don't say.
What does amended and restated on 339 mean? What's the restatement?
On 339.
Am I looking at the right? I beg your pardon, I'm so sorry. It's in very small figures. 229.
229.
Sorry,
yes,
it's part of
yes.
what we were looking at a moment ago.
So yes. So no, we haven't looked at this yet, my lord. This is what there are. So up to now, we've looked at the 2B contract and the Crown contract.
Yes. Sorry.
What we're now looking at is what we defined in the pleadings as the second 2B contract. And over at page 253, sorry, no, over at page 279, again, I'm sorry, I've got it, it's the wrong reference, I'm sorry. Page 188 is the actual correct reference. We have the second Crown contract.
Yes.
Apologies for the misreferences. And just to complete the picture, we also have third contracts, which happen at the stage of UK, and those are the documents at page 253 and 279.
So you've showed us the revised fund prospectus.
Yeah.
You're now showing us at page 188
Yes,
the revised Crown
that's absolutely right.
agreement,
Crown
this
agreement.
time with Astra LLP
That's right.
rather than Astra
Yes.
LLP.
And to answer my lord's question a few moments ago, what does amended and restated mean? That's a term which appears on the 2B contract, but as my lord sees, not on the Crown contract. But I think
Well, it does actually. It says this amended and restated.
Yeah.
The first line.
yeah, that's absolutely right at the top. Yes, it's not in the title, but it's in the in the first paragraph, and then under the preamble gives an explanation as to what that means.
Right, so what page should one
Page
be on to read
188,
that?
my lord.
Again?
So page 188. That's
Thank
the
you.
second Crown contract.
Right, so just
What
tell
it
me
records-
again, what does it mean to say that something is not only amended but restated?
I'm not sure I can answer that without giving evidence, but the best explanation, my lord, I can give is the preamble to the Crown contract, which is where the parties set out, as it were, the background to this agreement. And perhaps at the bottom of that paragraph on the page is the best answer I can give, namely that the discretionary management services are now going to be provided by the trading advisor pursuant to this agreement.
If you look at the next paragraph, it may give a bit more of a clue
Yeah.
over the page.
Yeah.
Refers
Yes, that's right.
to amending and restating in
Yes,
its
that's
entirety. I must say I would understand the restating as being, let's set out the whole agreement again with all the changes in it, rather than just say, oh, please amend clause 1 as follows.
That's probably a fair. Yes.
That's
The key point is that the parties And this is reflected in the way in which they sought to propose a new agreement in relation to the Octave contract. We'll see that in due course. The parties to this agreement did not feel it was appropriate to enter into a novation of the agreement. Instead, what they did was they simply entered into a new agreement, pursuant to which there was, if you like, a cut-off under old agreement and under new agreement. It did not extinguish the rights and obligations under the earlier agreement, but they simply entered into a new agreement that operated from a certain date. Now, and that's the way, that's the particular way in which they sought to conduct their business, both in relation to the trading agreements, but also, as we'll see, in relation to the Octave contract. We'll get on to that shortly. That is not actually a novation in law. That is simply entering into a new agreement. But what is absolutely right, and this is the central point I think that the judge alighted on and he considered to be significant. This is correct, that Astra LLP essentially stood in the shoes by entering into this new agreement. It wasn't novation, but it was a separate agreement. But effectively then took the place of Octave LLP under the Crown contract.
Okay, when you say it wasn't an novation, can you just understand? I understand what you mean in terms of the way it's structured, but can you also, really basic question, performance fees?
Yes.
As between Crown, sorry, which one is this? 2B or?
This is the Crown one. Page 180.
How do performance fees work insofar as they might have related to a period prior to the date of this contract? Because as you say, Astra was standing in the shoes.
Yes.
Investments might be held throughout in this account.
Yes.
Astra comes in, those investments continue to be held.
Yes.
May be realised.
Yes.
Is your understanding of the contract we're looking at now that Astra, because it has stood in the shoes, if you like, gets the whole performance fee, even if you could say that part of it related to an increase in value of the investment?
That would depend on the construction of this agreement, what performance fee is being payable in respect of something that happened.
Well,
in point of fact, I don't think the management fees have been paid.
Yes.
I don't think, from memory, that any performance fee had accrued at this point. That happened much later. I understand the question, of course I do, but I think the answer to it must depend on the proper construction of this agreement,
right?
Together with potentially the proper construction of the earlier agreement. Yes.
But the reason I'm asking is it's relevant, isn't it, as to whether Octave has completely dropped out of the picture, which is what the judge found.
Yeah.
Actually, made a factual finding to that effect, or whether
he summarised it in that way,
or whether you're saying, well, actually, Octave might continue to have some liability. I'm not sure whether that matters.
I think that there was obviously their entitlement as against the clients depended on the specific terms of their contract with the clients. There was the letter agreement that we looked at, Milady, but I don't. I'm struggling now to recall whether there was anything else. Obviously, that it could be the case, potentially, that it wouldn't be attractive to the client, but that there would be a fee payable to both parties. Or it could be the case that there was only a fee payable to one of those parties. But that is, if you like, is a theoretical possibility that didn't actually materialise, as far as I can see.
Right. I'm only asking because you're drawing this distinction between novation.
Yes. But it wasn't.
Would clearly have involved a release.
Yes.
Of the
it might have done, but it didn't, because there was no release of the first contract. All there was the second agreement. I mean, as a matter of fact, Octave LLP did not enter into a release with 2B and Crown. But what happened was Astra LLP entered into this second agreement, and that's just the way it operated. But if it assists, the key point here is that the role that Astra LLP was taking on was the role of Octave LLP. It wasn't the role of Octave Limited. And that's the significant point in my respectful submission.
This is 1st of September effective,
Yes.
and the payments continue to be made to Musst until nearly 2 years, until July 2016.
They'd stopped by then, but yes, I think the last payment was beginning of 16. Yeah.
I think it was May 2000.
Was it
Was it
May?
May?
Thank you. Thank you.
Right, well, same point.
Yeah.
And these payments were always made by Astra.
Astra LLP made payments, and then subsequently Astra UK made one payment, I think.
Right. Astra globally.
Right.
So, just help me with this. If this wasn't a novation, under what regime were these payments continuing to be made for another 18 months or 20 months?
So there was evidence about this in the trial as what Astra intended in particular. The judge and that they said that they were making payments by reference to a November, what was called a November agreement.
Yes, but we're not concerned with that any
We're
longer
not
because
concerned.
the judge rejected that.
The judge rejected that. That's right. And so we're left with a position that Astra LLP and Astra UK made a payment out of the money that they had received
Yes.
pursuant to these two agreements.
Yes, but what
The question,
on what legal basis in that case? Were they just doing it from the goodness of their hearts? And what was their? Is it your case that because this is not an novation, they were under no contractual liability to make any payments?
yes,
And in fact, that Musst has been overpaid.
no, but
So
no,
how-
but
how does it
the question,
play out?
if I may respectfully suggest, is whose legal liability it was. In the same way, as Octave LLP, we know that Astra UK made the first payment under the terms of the Octave contract, and we know that thereafter Octave LLP made payments under the contract. They were not liable to make those payments, and because they made the payments, my lord, it doesn't follow that they had the agreement.
No, I understand the point that,
Yes.
that other people may make
Yeah.
payments on your behalf
Yes, yes,
when they're not strictly liable to do so.
yes,
What I'm trying to find out is, in circumstances where you, to put it globally,
yeah.
went on making payments for 20 months after this agreement, what was the obligation upon anybody to make those payments?
The answer is there wasn't one,
Right.
unless it was pursuant to the November agreement.
Right. Well, in that it isn't pursuant to the November agreement, as we now
Yeah,
know.
yeah.
And so, is the consequence of the submissions that you've been making in detail, when one looks at it broadly,
Yeah,
that your clients went on paying for 20 months when they were under no obligation whatsoever to do so?
yes.
That's why I say they overpaid.
They didn't necessarily overpay,
Well, why not?
because there's the question as to who had the liability under the terms of the Octave contract. The liability was the liability of Octave Limited, and therefore when Astra UK at the beginning and then Octave LLP made payments, they were
If
making
Octave
them.
dropped out, then nobody had liability any longer. If the consequence of this agreement is to take Octave out of the picture, then it seems to be I'm checking this in case I've misunderstood, the logical consequence of your submissions, which I understand,
Yes.
is that at that point, if it had been thought about and Musst had delivered a subsequent invoice, then that could lawfully have been refused. So you're not entitled
could
to
have
this
done.
at all.
Absolutely, it could have done well.
Right,
That
so
is
it
my
leaves
position.
one thinking what these experienced traders are doing, paying invoices that they're not obliged to pay.
And I understand the question, my lord, but I can point to the fact that this was simply the arrangement that they had from the
I
very
understand,
beginning.
but I mean the consequence is not only that they've paid money that they were under no obligation to pay,
Yes.
but that when there's been this litigation, which engulfs the amounts involved,
Yeah.
they then don't ask for it back.
No, because they accepted in the case that there was an arrangement under which they were required to pay,
Yes.
and that they were paying, and so would it be inconsistent with them then seeking to get the money back.
Thank you.
And so, but in my respectful submission, the key point to focus on is the fact that, and this was nobody's case, that there was no novation either to UK or to Octave LLP of all the obligations arising under the Octave contract, merely because Musst invoiced Octave LLP and Octave LLP paid that invoice. And so what was happening, I entirely accept that Astra LLP moved into the shoes of Octave LLP so far as the 2B contract and the Crown contract is concerned. And I accept that Astra LLP continued to issue invoices and deal with the same arrangements in the same way that Octave LLP had done before it. I accept that. What I say, though, is you cannot draw, the court should not draw the inference that all of the assets, rights and liabilities under a contract were thereby being novated to that party, because that had never been the case. Parties have always operated as separate contractual obligation from the invoicing arrangements, and that's what's significant. This is not a case where an inference can properly, in my submission, be drawn from this change of invoicing, because it had never reflected
The point of this is not that it simply changed the person that should be invoiced, and so we needn't alarm ourselves about that. It just changed. But the point of this is that there was nobody that could be invoiced by Musst, according to your analysis.
Must's entitlement remained the entitlement under the Octave agreement.
Yes, but Octave no longer had the management.
Right.
So this isn't a case
entitled
where it could have sued.
Yeah,
It was entitled to 20% of nothing.
because
From that,
Octave
according
wasn't
to
owing
you.
the money. Absolutely. Its rights remained rights against Octave Limited. And if it was going to bring a claim, the claim that it would bring would be a claim for breach of
So what is it about this
9.4
agreement
or otherwise?
of September 2014? How does this fit in with the 2013 contract? What provision of the 2013 contract is biting on this, which means that no longer is there any meaningful remedy for Musst? Its rights have come to an end. How does it work through in
Yes.
the contract?
So this week, the case, Astra's case, is that the second and third agreements do not fall within the definition of funds under the terms of the Octave contract. The way in which liability would have been transferred from Octave Limited to Astra
Moves them
Capital.
away from being funds.
Yes. What ought to have happened if there was going to be a novation is that the liabilities and assets ought to have been transferred to Astra Capital and Astra LLP under the terms of the draft
Can you
agreement.
just, without us having to go back to the actual terms of the agreement, they're not funds any longer because?
They're not funds any longer because they're no longer being managed and advised by Octave.
No longer being managed.
Is this a point on clause 3.1 of the...
That's a clause 3.1 point.
3.1.
Okay, because the point being that looking at clause 3.1 of the Octave agreement, it's fees, it works by reference to fees earned and received by Octave.
Absolutely.
Is that the point?
That's the point.
It's not, I'm not sure it's strictly the definition of fund.
I
That
don't
might be
know.
a bit of a...
I see that.
Because another
No, you're
confusing
right.
point
My
in
lady
this
is
case
absolutely
is
right.
that
There are three particular requirements under 3.1 that I have referred to. The first one, the definition of funds. The second one, the definition of who's earning and receiving them, namely by Octave. And that's, if you like, the Octave issue as I've described it. And then the third one is the one about the funds. Yeah.
And it's that Octave issue that leads to my Lord's comment about 20% of nothing. Once Octave is not managing
Correct.
the funds,
Absolutely right.
there isn't any.
Absolutely right. And that is why the Octave contract provided a specific mechanism for dealing with that. But the key point that I want to get across is that the obligation to pay and the duration of the entitlement was limited to for so long as the fund was being managed and advised by Octave. So therefore, in order for Musst to continue its contractual entitlement, it needed to enter into an agreement with Astra Capital as the manager of the fund, and or as with Astra LLP, and that was what was proposed. That's exactly what was proposed, as you may have seen in the draft agreement. And it was, for the reasons which we'll see just in a moment, the directors of Musst were not available or were on holiday, and they never got round to signing the agreement. And that's why that agreement was not signed. But Astra Capital and Astra LLP were always willing to enter into that agreement until they no longer had the management of the fund again, when it moved again, at which point they withdrew the agreement. That is set out in the agreed chronology, and my lord and ladies, we can look at that in a few moments' time. What I would like to show you now, I think I've shown you the fact that the contracts, the 2B contract and the plan contract, moved over from Octave LLP to Astra LLP. And so I want to show you, if I may, the emails that were relied on.
This is quite a stretch of correspondences you're about to come into.
There's really not that many.
Right, well, I think it's very warm in here. Let's have a 5-minute break.
Okay.
We'll stretch the legs. Thank you.
All right.
As it's a 5-minute break, the live stream is going on.
Happy birthday. What did I do? 2 years running. I feel so bad. I know. 2 years running we've had Lucy working on my birthday.
It's a 5-minute break.
Thank you.
You back here?
Yeah.
I finished early, so I had a chance to give you a break. If I finished later, I wouldn't have been able to do it.
Yeah.
So I thought I'd ask you guys. No one else has responded, just you and the team. Right, you know what to do when they. So what you do in a couple of minutes, you just stand by that door, right? Make sure.
Normally the judges, they knock themselves and then they talk about it.
Do they? Oh, okay. I'm just telling you what the procedure used to be. Right. Well, if they go out for a 5-minute break, normally, I'll tell you this, but it's up to you. But you stand by the door there, right, and you make sure that the counsel is ready. So even if they knock on the door, right, if the counsel are not here, you just say to, excuse me, my lords, ladies, whatever. You say, excuse me, but counsel not ready yet. Can you give me just 1 minute? And then you go and fetch them, make sure they're ready, and then you let the judges in, because it's no point in them knocking, coming in, and they're not ready. You know what I mean? So you stand by that door just in case they come in and they're not back, because you don't know. 5 minutes could be 6 minutes. Yeah. And also, when you let them in, you're supposed to sit the presiding judge. You know, the centre judge.
Yeah.
You're supposed to sit with them. Do you know how to do that?
Yeah.
Okay. Only the presiding, because obviously there's only one of you, so you can only seat the presiding judge. The live streaming is not switched off, because it's only for 5 minutes. You just, and I've told them that live streaming is still continuing. All right. But that's how you do it properly. Because you don't want just walking in and looking ready.
Yeah.
Don't look good. You know what I mean? So in a minute or so, just stand there and wait for the judges. if they're all ready, then that's fine.
Yeah.
Then come in. If they're not, we just say, excuse me, council not ready. Can you give me 1 minute? I'll just go and get them ready. I'll come back and let you know. Cheers. I'll text you. I mean, I don't know what's going to happen in the afternoon. But I should be in a position to give you guys a break.
Okay, thank you.
But I'll text you guys. Keep an eye on your phone.
Pretty much.
Lord and ladies, what I'd like to do is just show you the invoices, the emails on which the claim to novation is founded. And they begin at page 344 of the supplemental bundle. And I will try and get through them as quickly as I can, but in short, what Musst was told by, in this case, Mr. Holdem, writing on behalf of Octave LLP, is that there had been a change of investment advisor. In fact, the words he used are trading advisor, which is, the Lord and ladies will know, that's the term that was referenced in the agreement in question, particular agreement in relation to Crown. So this is on the 5th of November 2014, and Mr. Holdem simply says that please note that due to the change of trading advisor from Octave to Astra Asset Management LLP, effective on the 1st of September, the fee invoice to LGT have been split. Please invoice us accordingly. That results in Musst on page 346 sending 2 invoices with the split that was suggested by Mr. Holdem. And as we'll see shortly, it is alleged by Musst that constitutes an offering and acceptance of a novation of all the terms of the contract, the entire Octave contract. So that's the rights and obligations both of Octave LLP and of Octave Limited. And what we say is this email does not constitute any such thing. At best, it indicates that there's been a change of the investment manager, and that the splitting of the invoices simply reflects the fact that it's now Astra LLP that is going to be receiving the money under the trading advisory agreement. After this, in terms of the chronology, the 2B, the second, what I've described as the second 2B contract was made. That's at page 229 on the 3rd of February 2015, so about 3 months or so later. And then similarly, on the 11th of February, similarly but even more thinly, on the 11th of February 2015, Mr. Holdem sends an invoice to Alexandra Galligan. That's at page 362. He doesn't say anything. He just says, please find the latest 2B invoice attached. And that's an invoice which is made out. That's the invoice that is at page 360.
360?
I think. Yes, this is an invoice from Astra LLP. and that's responded to by Ms. Galligan at the top of page 362. Just to confirm that we bill Astra as opposed to Octave for 2B LLC, and Mr. Holland replied on page 361, yes please. And then that invoice comes through on page 364, addressed to Astra LLP. And again, it's asserted that that constituted an offer and acceptance, but all of the rights and obligations under the Octave contract in relation to 2B were transferred by Octave LLP and Octave Limited to Astra LLP. And then we have Mr. Murray's email, and my lady Justice Falk asked me to deal with the question of the timing of this. The timing is that very short, it's about a week after that exchange that I've just shown you. Mr. Murray on page 366 writes to Musst to deal with the amendment of the introduction agreement, he says. And what he says is, in the second paragraph, I have amended the introduction agreement to facilitate the investment manager migration. And he says there are no substantial changes. It's effectively a name change with Astra Capital acting as manager and Astra Asset Management LLP as investment manager. So there is a gap between, as it were, the transfer of the Crown contract, but a very short one in relation to the 2B. That having been done, he's proposing a new agreement in which there will be a transfer, or at the very least an agreement, between Astra Capital and Astra LLP, and they will enter into the same obligations that previously were upon Octave Limited and Octave LLP, respectively.
So would it be fair to say that by this stage, you had done everything that you could have done to novate the agreement?
This was not a novation, in fact, that was being proposed. What was being proposed was a new agreement that had a new effective date within it. But yes,
essentially the same.
Well, okay. I don't want to quibble with the legal conclusion.
Yes.
That is important. A novation would involve the termination of rights under the earlier agreement, and that's not what was proposed. What was proposed was the entering into a new agreement between new parties. And the key point here, I mean, for this purpose, I don't want to quibble with whether it was a novation or not. The key point I wish to make here, my Lord, is that what was being proposed was not an arrangement under which Octave LLP would take over the payment obligation, but actually Astra Capital. Sorry, not Astra LLP would take over the obligation, but Astra Capital would take over the obligation. In other words, my Lord, what it was doing was not the very opposite, if you like, of what was suggested was being agreed, or had been agreed, and that this reflected. Namely, this was showing that actually it will be Astra Capital who will have the legal obligation. And that, we have the agreement behind this. I don't think I need to take you through it, but it essentially reflects that fact that it's only Astra Capital that will have the payment obligation, and Astra LLP would step into the shoes, effectively, of Octave LLP, so far as performing the administrative and operative functions that were previously that of Octave LLP. So that was the proposed agreement. The response to that at page 388 was at the bottom of page 387, Galligan to Mr. Murray, saying, I'll have a look at the new agreement and revert back next week, because they were in India at the time. And then at page 389 to 390 on the 4th of March, apologies for the delay. I've had a chance to look at this morning and everything seems in order. I will send a copy to our director who will need to review and sign. So that's the position of 4th March. And without putting a too fine a point on it, no further substantial progress was made with that agreement, and until it was withdrawn on the 20th of April 2016.
Well, there's some further things that go on in between.
There are some further exchanges I can show you, in particular.
There's a discussion about the effective date. I think.
Yeah, that's absolutely right, Milady. So if Milady looks at page 414, eventually there is an email from Mr. Saxena, who's the director. So the matter is then shown to Mr. Saxena, and he raises some concerns, and they're set out on page 414 in his email to Ms. Galligan. There are two concerns. The first one is in the first paragraph. He says the amended agreement is in effect a new agreement that will be entered into between Musst and Astra. There's no mention of the relationship between Octave and Astra. The second issue of concern is that this agreement will come into effect on the 20th of February 2015, which in a sense will be resetting the clock. And he says that there's no reference or recognition of the introducer agreement entered into between Musst and Octave on the 18th of April 2013. And then he says the convenient and simple solution to mitigate these issues is to utilise a novation agreement. So and that's why I say there is this difference which Musst were aware of between a novation and what was actually being proposed by Mr. Murray, which is an entry into a new agreement. And that then resulted in a conversation, and eventually, the conversation, I should say, is we have the transcript to page 415 through to 417, where Mr. Murray centrally, I think it's fair to say, Mr. Murray said, he said, it's the intention, that's not the intention. This is in the middle of page 415 of the second whole bunch in my bundle. The intention was, just so you know, because I suppose Astra, it's obviously not with Octave anymore, was just to ensure that, you know, there was a transitioning of accounts. And then at the end of the paragraph, it's effectively, it does novate the relationship, but on the existing contractual entitlements with Octave, up until the effective date, remain in place. So that is not a novation as such, where there's a termination of the earlier agreement. That's intended to stay in place. But it does represent, in Mr. Murray's word, a transitioning of accounts.
The look of this, which may or may not inform what the correct legal interpretation of it is that it never occurred to either party that payments should not be required or made while all this is going on. That wasn't the point. But your submission effectively amounts to the fact that they were both mistaken about what their legal obligations to each other were during this period.
I don't say that they were mistaken, my lord. I couldn't say that. I agree with my lord that what their intentions were is neither here nor there. It's a matter of law, what the effect of the exchanges that I've shown, my lord and my ladies, were. I entirely accept that. The other thing I'd say is this: that the parties had operated on a very for whatever reason, and perhaps it matters not why they did, but they always operated in this way which was outside the terms of the liability. That's my key point. And so the fact that they were still willing to operate outside the terms of the Octave contract is not significant. It doesn't have the resonance that in a different situation it might otherwise have.
You say, sorry, just interject on one point. You said intention was irrelevant. Well, there's an intention as to, or understanding of what the legal position is.
Subjective intention, I meant.
But intention, for example, to create legal relations is obviously highly relevant.
No, intention on its own is relevant. It's a question of whether it's subjective intention.
Yes.
Yeah, absolutely. its subjective intention is irrelevant, and what the parties said were their intentions to each other at the time is not subjectively, what they believed isn't necessarily the determining factor. What is the answer in my submission is the objective interpretation of those exchanges. And what I submit is that there was nothing either about the emails that I've shown you dealing with the invoicing that would lead to the conclusion that Octave LLP was accepting all of the rights and obligations under the Octave contract. It was limited to simply acting in the same capacity as Octave LLP had done before. And when one looks at the exchanges from Mr. Murray about the draft agreement, what that shows is a very different intention from the one that suggested should be inferred from the invoicing arrangements, namely a transfer of roles from limited to capital and from Octave LLP to Astra LLP, and not one in which Octave LLP had any contractual liability. And that is, so it's against the construction that's suggested in relation to the lawyers. And I submit that that's a matter of some significance in interpreting what the parties were saying to each other on an objective basis. What happened after that, as I think, ladies, you may know, is that Mr. Murray on the 20th of April 2016 sent another email, page 425, in which he withdrew the offer that had been made by Astra Capital and Astra LLP to enter into the revised draft agreement, because what had happened at this point was that, as set out in the first paragraph, Astra UK had submitted a change of legal status application for it to become regulated. And so it was no longer appropriate for for Astra LLP to be the investment manager under the terms of the draft agreement. And that then resulted in a situation where we have an exchange from Mr. Holdem, a further exchange from Mr. Holdem on page 426, where a very similar way that happened in relation to the alleged novation in relation to B, in relation to the Octave contract, alleged novation to Octave LLP, Mr. Holdem on the 10th of May 2016, this is the bottom of page 426, simply sent a copy of what he described as the latest 2B invoice to Musst. And that invoice is at page 427, and it requested payment into UK's account. That's the invoice to 2B. Musst submitted their invoice in response at page 430. And they did not change who they were addressing the invoice to on that occasion. So Mr. Holdem wrote the email, which is at page 428, on the 16th of May, saying, going forward, can you please address invoices to Astra Asset Management UK? So those are the exchanges in relation to UK. And
considering the email of the 20th of April withdrawing the offer of the agreement,
yes,
is that of any significance for the fact that there continues to be invoices submitted whoever to? What was the purpose in withdrawing from the agreement?
Well,
was that intended to say we're not going to pay you anymore?
No, I don't think it was.
What was it for?
What the parties were doing, Lord, is that they were making or trying to reach an agreement that would govern their relations going forward. The invoicing, I submit, is not significant to the contractual position, and that's why it didn't affect the invoicing that was going on.
Right, so on the basis that they didn't have to pay anything beforehand, it makes no difference to whether they paid anything after either. It's a...
That is correct, because they never... That is correct.
Okay.
Astra Capital would have been the party liable under the terms of the revised agreement, but the agreement wasn't made, so it never obtained transfer of liability. Astra LLP never had liability under the terms of the agreement. The fact that it was paying some of the fees did not mean that it necessarily meant that it therefore also took a novation of the agreement for any more reason than Octave LLP had not been liable.
Was that the last invoice paid?
That is the last invoice paid. The May invoice.
Yes, the May invoice.
That's the May invoice. And so it was addressed. I've shown the invoice. It was addressed to Octave LLP. It was paid by Astra UK. And what then happened was there were discussions between the claimant's representatives and Astra representatives, in particular, Mr. Martha, and once those discussions had started, Astra no longer was willing to continue following this process. And we see that at page 436. Exchange on the 16th of June, where Ms. Imanek emailed Mr. Holdham asking him if they had received the May invoice for 2B. And Mr. Holdham responded further up the page. I understand discussions are being held between Salim, Alexandra and Anish on this subject. So at this point, Astra was no longer performing. And the last bit of the jigsaw is page 446, where that being the position...
Could we just look at 435?
Yes.
Which is internal.
Yes, yes. This is an internal email from Mr. Holdham to Mr. Martha, which was an email sent arising out of one of the discussions that took place.
Thank you.
And but in terms of what crossed the line, as it were, between the parties, we can then move to page 446, Maynard. Which is Mr. Siddiqui.
Well, there's quite a long discussion at a meeting.
Oh, there are absolutely.
Line,
There are meetings, absolutely.
You're taking us to 446.
I am indeed. It's quite right that there were meetings and discussions and various suggestions were made by Mr. Martha, but I don't think they're really central in my submission to the analysis. What is central is that there was this email from Mr. Holdham in a similar way, saying, in future, can you address your invoices to UK? That wasn't done at the time, but it was directed to the future. There then were discussions between the parties in the way that I've just very briefly outlined. And then, after those discussions on the 28th of July, page 446, Mr. Siddiqui made a claim.
What's the significance of them not having sent it to UK? It wasn't going to be paid anyhow.
This is the May invoice.
Yes.
It was paid. That was the last payment that was made. The significance is this, my lord. The claimant relies very heavily on the fact that there was a change of invoicing from originally Octave LLP to Astra LLP, and then it's at the point in July that we get for the first time invoices addressed to UK. My point is that in May there wasn't an invoice addressed to UK at that point, and yet, notwithstanding that, it's the claimant's case that the submission of an invoice to LLP was the acceptance of an offer by UK to be liable under the terms of the Octave contract.
Although I hesitate to interrupt, that's not our case,
Right.
if I may be forgiven.
Okay, well, let's stay with
I can go to the pleadings.
what's saying, but at the moment, you said invoice UK.
Yeah.
They didn't. But when they did, you didn't pay it.
That's true. Yes, that's absolutely true. And that's why I'm completing the review, as it were, of the documents with this email from Mr. Siddiqui on the 28th of July, where Mr. Siddiqui said, you haven't complied with the terms of the agreement, and I'm submitting invoices. And now he's saying he's submitting them to UK. And indeed, we have them immediately after the email in the bundle. And you can see that that's the first invoice is addressed to UK. It is also submitted by the claimant that constituted the acceptance of an offer that had been made by Mr. Holden back in May. And the Astra's case on that is that, in fact, what's happening is this is a claim for payment in circumstances where there'd been a dispute had then arisen, or a disagreement as to where liability lay. Astra was no longer willing to perform. That's clear from the emails that I've just shown you. And it's that non-performance that has given rise to this email. So on the contrary, it doesn't show that there was any agreement. It shows that there's a lack of agreement. And that's the point I wish to make on this email. So, my lord and ladies, unless I can assist you further, those are the submissions I wanted to make on the documents. In terms of the legal principles, I indicated earlier that there was really no dispute between learned friend and I on this, and we make no criticism of the judge's analysis of the legal principles relating to novation. But if it assists you, could I just give you a reference to the part of the judgment where the learned judge deals with that, and also some references, if it would assist you, to the cases he referred to. The judgment is in the core bundle, and the tab 7, and it's page 189 that I would draw your attention to, under the heading the law. In short, my lord and ladies, both parties, I think, accept this analysis and summary of the law that's set out in the judgment as operating.
So it's from 324 to 332.
Yes, it is. And the points that I would emphasise are these. In 324, that the usual principles relating to the formation of contracts apply to novation. And with the consequence in the last sentence set out that you need to have offer acceptance, you need to have certainty of terms, you need to have consideration, and you need to have intention to enter into legal relations. 325, that although a contract can be novated by conduct, in the same way that any contract can be made by conduct, acceptance, this is in the middle of the quotation from Chitty, acceptance, there's a sentence 6 lines down, acceptance may be inferred from acts and conduct, but ordinarily it's not to be inferred from conduct without some distinct request. And the reason I draw that to your attention is that none of the exchanges that I've shown you, pursuant to which it was said that this is a novation, they even refer to the contract. And so, you know, the parties were not, when they were writing those emails in my submission, directing their minds to the contractual rights and obligations under the Octave contract. What they were directing their minds to was the mechanism whereby payments would be made. And it's a simple, you know, that's an administrative operative function that had been provided to Octave LLP under the terms of the Octave contract. But as I tried to submit earlier, that's not a mechanism, as it were, that has a contractual force.
But
it's simply the way
if somebody is spending their time exclusively on the mechanism by which payment is going to be made, does one not readily infer that they're agreed that payment is going to be made?
No. And the relevant question in my submission isn't necessarily whether or not payment will be made, but who has the relevant question for the purposes of novation is who has the obligation, the legal obligation. Because there could be all sorts of reasons why, for example, a parent company would want to discharge the bills addressed to a subsidiary, or a husband might want to pay a bill that's addressed to the wife. That's just the way in which life works, commercially and in personal relations. It doesn't follow from that there's a legal transfer of the liability, or simply because a person says, well, I'm willing to discharge this bill, that he's accepting that he has the liability in the contract. In order to find that, you have to have, I submit, a clear reference to the contract, or what's described as a distinct request. And that distinct request has to involve not just the new parties, my lord and ladies, it has to involve all the parties, because a novation involves the extinguishment of the rights and liabilities between the old parties and the creation of a new relationship between the new ones. And that simply doesn't exist in these exchanges, the involvement of all the parties in question.
Which parties were absent?
In the first exchange that I showed you, that was an exchange between Musst and Octave LLP only. In the second exchange, it was an exchange between Musst and Astra LLP. And in the third exchange, that's the UK exchange, it was between Musst and Astra UK.
But they all know what's going on. They're the same people.
Well,
I mean, I realise they're
they
corporate differences, but
yes,
everybody involved, everybody on each side knows what's going on in all the parts of their own side.
Well, Octave Limited. The judge did say that there were common employees between Octave LLP and Astra LLP, and that was right, although they moved over from one to the other, that is true. It wasn't the case in relation to Octave Limited, nor was it the case in relation to Astra Capital. So the party or the parties that were going to either were liable or were going to be liable were not parties to these exchanges.
I understand they're not parties, but they're all vehicles for the same commercial venture with the same guiding minds.
Well,
I mean, I can understand your
they're not
point
all.
if you were saying with innovation that this was meant to involve 2B or Crown, some of the investors who weren't even considered in this. But it's not that. This is all in-house.
That, my lord, it's right to say that Mr. Martha was involved right at the outset. He was involved in Octave LLP because he was the registered representative of that company. And he was involved in Astra LLP because he was the director, was ultimate owner and part of that company. It doesn't follow from that there's a communality of employees, that when a party enters into a contract on behalf of one company, he's entering it into on behalf of all of his companies. And that communality, my lord, doesn't extend, as I said, to the parties actually liable. That is to say, Octave LLP and Astra Capital.
I understand.
And so, when a party said, well, don't invoice A, invoice B, and don't invoice B, invoice C, it doesn't follow from that they were accepting a transfer of rights and obligations under the contract. They wouldn't have been in a position to do that, and they weren't actually directing their minds to that at the time. And that goes all the way back to that important distinction between the manager and the investment manager. So looking again still at the law, my lords, lord and ladies, there's a reference in 326 to a case called CEP and Stenny. I won't take time by taking you to that, but I would just point out that we have that in the bundle of authorities at tab 4, page 55, and I would recommend to you paragraphs 31 and 35 of the judgment. And the reason I do that is, and I draw attention to that case, is because this was a case where there was a transfer of business from one company to another company, and there was also a request to redirect invoices. So we have a similar situation I don't say it's on all fours factually, because every case is different. But the point I would make is this. that the very same things that are relied upon by Musst in this case, namely a transfer of functions and re-invoicing, were relied on in this case. And Mrs. Justice Gloucester found that the evidence did not establish that there was a novation from one to the other company. And the reason I reference that is just to make the point that I've already made, that when you look at requests for invoicing, they may or may not be relevant. In Sepp and Steny, it was not relevant, and for the similar sort of reasons, I submit, it's not relevant in this case. Finally, at 327, I draw attention to the Tichy.
Sorry, the paragraphs you wanted us to look at are 31 and 35?
35. Yes, my lady, yes.
Oh, 35.
Yes, indeed. At 31, Mrs. Justice Gloucester held that this was not a novation.
Okay.
That the request to transfer invoicing was not an offer to novate, because what was being done was a change of the operating company. That is to say, the company involved in the operations of the business in a similar way to, in this case, Astra and Octave LLP. In paragraph 35, Mrs. Justice Gloucester made the point that in any event, this such a change would not comply with the no oral variation clause that existed in that contract, in the same way that it exists under two clauses in this agreement. And she said that change of invoicing wouldn't satisfy the requirements of a no oral variation clause. That's a further point that I make in relation to this particular agreement, because the parties anticipated that it might happen, that there would be a change of management of the funds, but they also agreed in clauses 16 and 17 that without more would not amount to a variation or a novation of the agreement. But in order for that to happen, there would need to be a written agreement, which is what the parties were trying to achieve. So that's Sepp and Steny. In 327, the learned judge then turns to the Tichy number 2 case, which went to the Court of Appeal, where the judgment of the Master of the Rolls, Lord Phillips, is of some relevance. It's fair to say the judge summarises that between 327 and 331 admirably. The points are these. At the bottom of the quotation at 327, Mr. Justice David Steele said that the consent, that is to say, to an innovation, must be clearly established on the evidence as being only consistent with an intent of achieving innovation. And then in paragraph 328, the judge references the fact that that was referred to without criticism in the Court of Appeal. Indeed, the Master of the Rolls said, in the words then quoted, clear evidence of an intention to produce innovation is likely to be needed if that standard of proof is to be discharged. With that proposition, we would agree. So that was endorsed in the Court of Appeal. And then 329 deals with the subjective intentions point, that not being relevant. And 330 deals with the point as to conduct, and in particular conduct after the date of the alleged novation. And the normal rule applies, which is set out towards the bottom of 330. Namely, while the conduct of the parties after an alleged novation contract can be relevant to an estoppel, it's not legitimate to have regard to that as an aid to construing the meaning of the words used. And then there's a summary at 331, which I recommend to my Lord and ladies. Namely, that if the exchange of faxes did not, on their true construction, constitute a novation agreement, or were ambiguous as to whether or not there was such an agreement, then the applicant, in this case the claimant, can only establish that the novation occurred if they can demonstrate that the conduct of the parties afterwards gave rise to an estoppel. And I submit that that's exactly the position that the court is in here, which is that the emails that I've shown you don't establish clearly or at all that there was a novation between the parties, and the subsequent conduct that is relied on as consisting of the payment after the invoices were rendered can only support a estoppel. It cannot, as it were, retrospectively inform the construction of the emails themselves. And then paragraph 332 makes the point that of the need, 2 further points, again by reference to Chitty, that first of all, that consideration is required for the provision of a new contract, and secondly, in the next sentence, that because a novation is different from an assignment, it follows that you don't take subject to equities. When you take a novation, you take a clean contract, namely the contract that you're entering into with the new party. So that's the background in terms of the law. And in terms of paragraphs, if my lord and ladies wish to look at the teaching number 2 in a bit more detail, I would recommend paragraphs 19, 22 to 24, 32 and 36.
Do you have what tab is that in your?
That is in tab
Oh, it's tab
11.
I think.
Yes.
Thank you.
And my lord and ladies, we've also provided you with the latest edition of Chitty, been updated since the one that was before the judge. And that you'll find in, I think it's tab 7. No, sorry, tab 16 of the authorities bundle. And in particular, I would recommend paragraph 332.
Does it work in this way, that
Yes.
that if you have the material that establishes estoppel by convention, you've achieved what you would need to achieve to establish novation?
No, I wouldn't.
Well, I'm just looking at 331. I'm
Yes.
just trying to
Yes.
understand
Yes.
the significance
test- Yes.
of B.
Yes.
But suppose you get over A,
Yes.
and we're on to B.
Yeah.
Can only establish novation if it's demonstrated that conduct has given rise to an estoppel by convention.
Yes.
So that, just as a snippet taken on its own, might suggest that these are simply 2 sides of the same coin, namely that if you had, when, as you did,
Yes.
lost on the point of estoppel by convention,
Yes.
as the judge found that if it wasn't a novation, that's what it was. But actually this suggests that they're the same thing achieved by different means.
Well, I think what I may respectfully suggest this is directed towards is the conduct, particular conduct that's relevant. The conduct that's relevant to a contract are the exchanges of emails, not what happens afterwards. The conduct that's relevant to the estoppel could be what happens afterwards, but the fundamental requirements for a contract are different from the fundamental requirements of an estoppel.
Well, that's why I'm
so it
alighting on
doesn't
this
follow
particular small
Yeah.
paragraph, which
Yes.
seems to suggest that they amount to the same thing. But
I would submit.
is that either not correct?
I don't
or I've
accept.
misunderstood
No,
it?
I don't. With respect, I don't think that's what that paragraph is saying. I think it's saying that no, you are not allowed to take into account subjective intentions in the contract. Or post exchange conduct. That may be relevant to an estoppel, but it's not relevant to a contract.
But it may be saying that if you do manage to establish an
Yes.
estoppel, including by reference to subsequent
Yes.
contact, that is tantamount
That's what I'm
to
reading.
a novation. That's maybe how it should be read.
I entirely accept that an estoppel could amount.
consequence.
Yes,
The
an
consequence.
estoppel could amount, depending on its terms. An estoppel could amount to essentially the same thing or achieve the same result.
Yes.
You are stopped from denying liability under a contract. But fundamentally, that's not necessarily the same thing as taking a novation. A novation involves not just you as a party, but all sorts of other parties. And it has effect, as I said before, of terminating a particular contract and then bringing into existence an entirely new contract with different parties. An estoppel acts entirely in personam and on the well-established principles which the judge sets out in his judgment. Again, I make no criticism of them. If it assists you, there is a discussion there is a discussion in the judgment, paragraphs 307 through to 310, which sets out in broad terms the principles of estoppel. So I wanted to, if I may, I see the time, my lord and ladies, and I don't know what time you'd like to take a break.
How are you getting on?
At the moment, it's taking me a little bit longer than I would have anticipated going through my notes. But I was rather hoping that I would be finished on the novation ground either around now or within the next sort of half an hour. I would try, if I may, and
All right. Well,
through
do you want to give us the headlines of the argument now, and then come back at 2 o'clock? Would you
I
rather
can do.
Or would you rather
I
break
think,
now? And
I think
start
probably I'd rather break because
you can tell.
I want to very briefly show you the pleadings and then look at the judgment on the novation point.
All right. Well, we'll resume at 1:55 in that case.